Hi everyone, I am Krishna Marie Belieza, and today I will going to discuss my report about treatment of aliens. Treatment of aliens general rule. An injury to a citizen is an injury to the state. A state therefore has the legal responsibility to citizens of other states coming into their jurisdiction, and a legal interest in ensuring that their own citizens are not harmed by the conduct of other states or of foreign nationals. Sovereign power, flowing from its right to existence and as an attribute of sovereignty. No state is under obligation to admit aliens. The state can determine in what cases and under what conditions it may admit aliens. Number one, this right includes the power to regulate the entry and stay of aliens, and the state has the right to expel aliens from its territory through deportation and reconduction. Expulsion or deportation. It may be predicted on the ground that the stay of the alien constitutes a menace to the security of the state that his entry was illegal, or that permission to stay has expired, or that he has violated any limitation or condition prescribed for his admission and continued stay. Reconduction is the forcible conveying of aliens back to their home state. Thus, destitute alien, vagabonds, aliens without document, alien criminals, and the like may be arrested and reconducted to the frontier without any formalities, and the home state of such aliens has the obligation to receive them. The alien must accept the institutions of the state as he finds them. Accordingly, the alien may be deprived of certain rights, like political rights, acquisition of lands, and etc. However, local laws may grant him certain rights and privileges based on reciprocity, most favored nation treatment, or national treatment. But these privileges confirmed may be revoked subject to treaty stipulations. International minimum standard. This standard means that a state must treat foreign nationals within their territory based on an international minimum standard as agreed upon in treaties and other conventions. This includes the right to life, liberty, protection of property, and free access to the courts. The international minimum standard exists regardless of how the state treats its own citizens. This standard is preferred by developed countries. National standard. This standard means that a state is not in violation of international law as long as it treats foreign nationals in the same way it treats its own nationals. This standard is preferred by developing countries. Fundamental human rights. Currently, there is a move to come up with a list of fundamental human rights, which will serve as the global minimum with regard to the treatment of both foreigners and nationals. As of now, the closest there is to a list of fundamental human rights would be the UN Declaration of Human Rights. However, as it stands, states are still free to choose between applying the international minimum standard or the local standard when dealing with foreign nationals in their territory. State responsibility and treatment of aliens. A state is under obligation to make reparations to another state for the failure to fulfill its primary obligation to afford. In accordance with international law, the proper protection due to the alien national of the latter state. The state may therefore be held liable injuries and damages sustained by the alien while in territory of the state if the act or omission constitutes an international delinquency. The treatment of the alien should amount to an outrage, to be bad faith, willful neglect of duty, or insufficiency of governmental action, such that every reasonable and impartial man would readily recognize its insufficiency or inadequacy. Intentional standard justice, the standard of the reasonable state, which means reason able according to ordinary means and notions accepted in modern civilization. Execution of an alien without trial is considered as falling below the intentional standard of justice. Number 2. The act or omission is directly or indirectly importable to the state. Even when the laws of the state conform to the international standard of justice, the act or omission causing damage to the alien may be indirectly imputable to the state if the latter does not make reasonable efforts to prevent injury to the alien, or having done so unsuccessfully, fails to repair such injury. The act or omission which will give rise to liability may either be A. Acts of government officials. Acts of primary agents of the state, example given is the head of state, are acts of state, which will give rise to direct state responsibility. Acts of high administrative officials, within the sense of their authority, are also acts of state which could give rise to liability. Acts of private individuals. For the state to be held responsible, it must be shown that there was actual or tacit complicity of the government in the act, before or after said act transpired, either by directly ratifying or approving it, or in the patent or manifest negligence in taking measures to prevent injury, investigate the case, punish the guilty, or to enable the victim to pursue his civil remedies against the offender. 3. There is injury to the claimant's state indirectly because of damage to its national. Next is state responsibility and expropriation. Number 1 is compensation. There can be no valid expropriation without payment of compensation. However, the question of which formula to use for computing compensation is still an ongoing debate. There are two types of compensation. First is the Hall formula, named after its creator, Cordell Hull, who was Secretary of State during the Second World War. The formula essentially provides that compensation should be adequate, effective, and prompt. Next is the adequate compensation. As opposed to the Hall formula, adequate compensation simply takes into consideration the fair market value of the property when computing for how much compensation to give. Indirect expropriation. Indirect expropriation or disguised expropriation occurs when the state subjects the property to restrictions that ultimately amount to an expropriation. An example of this would be subjecting private property to indefinite governmental control. Next is the enforcement of alien's claim. Exhaustion of local remedies. An alien must first exhaust all available local remedies for the protection or vindication of his rights, because the state must be given an opportunity to do justice in its own regular way and without unwarranted interference with 18th sovereignty by other state. As such, diplomatic protection does not generally come into play for as long as exhaustion has not yet taken place. Number 2. Resort to diplomatic protection. After the alien has exhausted all available local remedies without success, he must avail himself of the assistance of his state. Next is the modes of enforcement of claims. Through negotiation, or if this fails, any of the other methods of settling disputes, like good offices, arbitration, or judicial settlement. When the responsibility of the state is established, the duty to make reparation will arise. Reparation may take the form of restitution, or where this is not possible, satisfaction or compensation, or all the three of these together. Extradition, the surrender of a person by one state to another state where he is wanted for prosecution or if already convicted for punishment. Basis of extradition is a treaty. In the absence of a treaty, surrender is made. The same is merely a gesture of the local state may grant asylum to the fugitive, or if surrender is made, the same is merely a gesture of committee. Distinguished from deportation. Extradition is the surrender of fugitive by one state to another where he is wanted for prosecution. The surrender is made at the request of the latter state on the basis of an extradition treaty. Deportation is the expulsion of an alien who is considered undesirable by the local state, usually but not necessarily to his own state. Extradition, not unilateral. While deportation is a unilateral act of the local state pursuant to its own interest, extradition is not. This is because extradition requires the transfer of an individual from the sending state to the requesting state on the basis of a treaty obligation. As such, it is improper for extradition to be characterized as unilateral process. B. Executive fiat. Despite extradition proceedings commonly taking place in a court of law, they are ultimately characterized as administrative proceedings. As such, the only question involved is whether to extradite or not. Given the administrative nature of these proceedings, it follows that the head of the executive department is the ultimate decision maker with regard to whether or not to extradite. Thus, regardless of the outcome of an extradition proceeding, the head of the executive department may still reverse the same. These are the fundamental principles. Based on consent, as expressed in a treaty, of manifested as an act of goodwill. Next is under the principle of specialty. A fugitive who is extradited may be tried only for the crimes specified in the request for extradition and included in the list of offenses in the extradition treaty. The state of refuge has the right to object to a violation of this principle. Then, any person may be extradited whether he is a national of the requesting state, of the state of refuge, or of another state. Next is political and religious offenders are generally not subject to extradition. Next, in the absence of special agreement, the offense must have been committed within the territory or against the interest of the demanding state. Next is the act for which extradition is sought must be punishable in both the requesting and requested states. This is known as the rule of double criminality. 4. Procedure for extradition. A. Request. Accompanied by the necessary papers relative to the identity of the wanted person and the crime alleged to have been committed or of which he has already been convicted, made through diplomatic channels to the state of refuge. Upon receipt of the request, state of refuge will conduct a judicial investigation to ascertain if the crime is covered by the extradition treaty and there is a prima facie case against the fugitive according to its only laws. If there is, a warrant of surrender will be drawn and fugitive delivered to the state of refuge. In this case, the court likewise rules that extradition proceedings are sui generis and do not trigger any application of the right of the accused. Furthermore, although due process demands that the individual who is subject of the extradition proceedings is furnished a copy of the petition, there is no legal basis to require him to be furnished copy prior to the filing of the petition itself. RP's extradition treaties. The Philippines has concluded extradition treaties with Indonesia in 1976, Australia in 1988, Canada 1989, Switzerland 1989, and United States of America in 1994. All these treaties follow the non-list type of double criminality approach where there is no traditional listing of crimes, as this could lead to difficulties where the countries denominate crimes differently. Letters rogatory, a formal communication from a court in which an action is pending to a foreign court, requesting that the testimony of a witness residing in such foreign jurisdiction be taken under the direction of the court, addressed, and transmitted to the court making the request. So, what is the meaning of asylum? Asylum is the power of the state to allow an alien who has sought refuge from prosecution or persecution to remain within the territory and under its protection. This has never been recognized as a principle of international law. There are two types of principles on asylum: the territorial asylum and the diplomatic asylum. Territorial asylum exists only when stipulated in a treaty or justified by established acts. It may depend on the liberal attitude of the receiving state on grounds of territorial supremacy, while diplomatic asylum is granted only if stipulated in a treaty or where established usage allows it, but within the narrowest limits or when the life of liberty of the person is threatened by imminent violence. Rule in the Philippines: generally, diplomatic asylum cannot be granted except to members of the official or personal household of diplomatic representatives. On humanitarian grounds, however, refuge may be granted to fugitives whose lives are in imminent danger from mob violence, but only during the period when active danger persists. Essential elements: outside the country of his nationality, or if stateless, or outside the country of his habitual residence. B. Lacks national protection. And C. Fears persecution. A refugee is treated as a stateless individual, which he is either de jure or de facto. The Refugee Convention of 1951 does not deal with admission, but with non-refoulement. Example is that no contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom is threatened. The state is under obligation to grant temporary asylum to refugees. Thank you.